take me off of that. Pin me there, hit okay. All right, good morning. I'm going to call the docket in just a moment. Before I do that, attorneys know that after I call the docket, I'm going to call Judge Banner is appearing today as a visiting judge on Mr. Michael Green. We're going to call that case first with Mr. Merleader. After that, if the attorneys will that want to be called first, will form a line over here. I'll know how to call you up. We're going to do that. As I call your name, please say present or here so I can acknowledge you for the docket. Lemmy Brandon. Lemmy Jean Brandon Jr. Bryce Carroll. Here, where? Thank you. Christopher Hawkins. Christopher Bernard Hawkins. Stacy Rash. Raul Lopez. Thank you, Mr. Woodward. Grace Fowler. Jacob Frericks. Damon Gutierrez. No, Damon. Damon Jacob Gutierrez. Calling defendants, not attorneys, Mr. Damon Gutierrez. Damon Gutierrez is? I'm looking for Damon Jacob Gutierrez. Kobe Heron. DeAnthony Darnell Smith. DeAnthony Darnell Smith. Carlton Mitchell. Verified in the Smith County Jail. We'll recall that case. Keith Mays. Keith Bernard Mays. Adrian Gutierrez. Thank you, sir. Tanner Sistruck. Thanks, sir. Ralph Hanselka. Francisco Chaparro. Francisco Lorenzo Chaparro. Anyone seen Mr. King? Heaven Weed. Brandon Harrison. Confirmed. Is he confirmed in Wood County Jail? Michael Green. Samuel Turner. Jamie Nail. Thanks, sir. J. Byron Riddle. J. Byron Riddle. Oh, hang on, that might be a COVID issue. We'll recall that in just a moment. Carlos Cabrera. Thanks, sir. For the record, Mr. Sanders is in trial today. His cases have been moved to 8/26. That include Haley Gandy, Travis Skinner, Amethyst Wesley, and Deshaun Whitaker. Joshua Flores. Is Joshua Flores here? Dakota Dubose. Dakota Dubose. Amy Heron. I believe Ms. Heron is appearing via Zoom. Excuse me, Harmon. And she is present on Zoom. Misty Rice. William Robertson. Tracy Smithart. Ronald Toll. Troy Burgess. Troy Wayne Burgess. Stuart Haywood. Stewart Haywood. Keith Thomas. Claudia Cook. Ms. Cook, did you say here? Okay. Jeremy Reeves. Waiver of arraignment filed, approved, pretrial set 10/14. Aaron Blevins. John Lopano has been verified in custody in Cameron County. We'll recall that case. And then the last one is at 11. So Mr. Green, if you'll step up to the podium, Mr. Murrow Leader, we're going to bring Judge Banner in at this time. Judge Banner. Judge Banner. Shows me to send an order.
This one, yeah.
We're not ordering him to be here today to sound pre-trial release conditions. Yeah, I've got the waiver, but he's supposed to be here.
Judge Banner. Yeah, go call him, please.
Did we file waiver of arraignment back?
Hang on, let me call that case real quick for the record. Cause number CR 21-171, State versus Brandon Lee Harrison. Go ahead, Mr. Manning.
Did we file a waiver of arraignment back on June 25th? It appears that Amanda Penn's not got a hold on him, so he was not brought over for this docket. If you would like to make yourself available, here via Zoom this afternoon. The jail docket, either in person or at my office, we need to make an announcement. At this time, we have a plea agreement worked out. We're just waiting to get his body back here, so we can take care of that. My understanding is he has holds out of 3 other different counties besides Wood County, so maybe a while before we get it back.
So, okay, so let's do this. So no contested pretrial motions. All right, so do we want to just set this for a plea and do a bench warrant and having brought back from Wood County, conclude our business?
We can do that, Judge.
Okay, court will set this for plea. Do you have a proposed date that you're available, Mr. Manning, that if we're looking, 30 days out or so to get Mr. Harrison back, I would be looking at September. Getting pretty full already. September 28th, maybe?
That'll work, Judge.
All right, Mr. Harrison's in, we're gonna set him for plea on September 28th. And that'll be at 1:30. Yes. All right, Mr. Murrow Leader, is he still in the courtroom? Mr. Murrow Leader, we're gonna try it again. Mr. Green. Good morning, Ms. Husky.
Good morning, Judge. How are you?
I'm doing great. I'm going to bring in Judge Banner at this time, and I think he'll be ready. And then Mr. Murrow Leader's here and Mr. Green are here. Let me change this real quick. Good morning, Judge Banner. Can you see and hear me okay? All right, I'm going to prompt you to unmute there.
And now am I unmuted?
You are unmuted, so to speak. All right, so this is your cause number CR 19-232, and present in the courtroom are Mr. Murleader, counsel for the defendant, Mr. Michael Ray Green, and Miss Alicia Husky, special prosecutor in this case, is present on Zoom. So I'm going to turn off my camera and allow you to conduct your hearing. Go ahead.
Good morning, counsel, Mr. Green. All right, today, this is a pretrial hearing. I've noted that the state has filed a motion asking that that the defense identify any experts that it intends to call. Is there any problem about that, counselor?
No objection to that motion, sir.
All right, it's granted. Now, and I also note that the state has filed a list of its witnesses, which I assume takes care of that. The clerk did not, or the coordinator did not forward to me any defense motions. Are there any defense motions?
Judge, we had filed the standard motion in limine.
I'm sorry, counselor. I'm not hearing you very well.
Apologize, Judge. Can you hear me now?
That's better.
Judge, we filed our standard motion in limine. We filed an application for probation and election as a punishment to the jury.
Okay, the election of punishment to the jury, that's just automatic. Once you file that, an application for probation automatically makes it go to a jury in the event of any conviction of anything. Your standard pretrial motions, Madam District Attorney, have you examined those? Any issues?
Your Honor, the only issue that I would raise is that the motion in limine requests to keep out oral statements that were made to law enforcement officers. And I would just explain to this court that any statements that were made were not under interrogation, or they were made after Miranda had been read to the defendant, and then it was offered up by the defendant. No, and there was no violations in those.
That's correct.
Okay,
We're not contesting Mr. Green's motion about oral statements made throughout the interrogation or interviews in the case. What I'm asking for in the limine is that if the state is planning on using such evidence, just to approach the court before presenting it.
Okay, are these custodial statements, or is this just the initial contact made by the officers?
I believe it's the custodial interrogation where my client waived his rights. We didn't file any motion to suppress or anything like that, so it's a valid interrogation.
Okay, well, here's what we're going to do. We need to develop it a little further. Right now, is that I'm going to treat it as a motion in limine before the defendant's going to be quoted in front of the jury. We will, at a better, more handy time, because one thing I'm having trouble hearing the learned lawyer for the defense, but if I understood what he said, is that it seems to me to be appropriate that we will just take that matter up perhaps after we've got a jury selected, and then we can look at it whether any or all of those things are going to be presented in front of a jury. It's pretty easy for something that's not going to be admissible is because of something the defense does that changes it. So I'm just going to treat it as a limine. Now, was that the limited motion you were talking about, counsel?
That's correct, Judge.
Okay, anything else we can do?
Judge, I had asked Ms. Husky to provide a list of prior bad acts.
Well, as I understood it, the defense didn't have any, or rather the state was not objecting to your motion other than the question of the attempting to quote the defendant before the jury.
That's correct,
The
Your
rest
Honor.
of it is granted unless I'm hearing something to the contrary.
No, Your Honor, I do not have any issue with any of the other requests, and the state intends to comply with the rules of evidence.
Anything else by way of motions that we can address?
Not from the state, Your Honor.
Okay, now, what's the situation in Van Zant County on jury selection? Because that's the next thing. What I want to do is, if we can, is get a date for the final pretrial to make sure that we really need a jury, and a date to select a jury. I assume COVID continues to disrupt our world, at least the court world. And, but I don't know what, I assume the coordinator or somebody can tender some dates.
Judge, last hearing, you scheduled a trial date of November 15th, and I got the go-ahead from Judge Chris Martin that we're full steam ahead for jury selection.
You say you think you've already got a November 15?
Yes, Judge. Last time you scheduled a November 15th at 9 a.m. Trial date.
All right. Okay, well, apparently we've got that approved. So here, let's leave it this way. On the final pretrial, what's the usual practice in Van Zandt County? Obviously, what we're trying to do is figure out, do we need a jury? And if in the, because the matter may or may not resolve itself. Obviously is that if Judge Martin is going to schedule other cases, which I assume he would, maybe he doesn't, but if he does, then I assume that it would be a real handy for Judge Martin, the court over there, and the other lawyers with other cases, just so that their planning can be a little more efficient. Now, in this case, everybody here, except Mr. Green, apparently doesn't have anything to do with Van Zandt County. That is to say, we're from somewhere else.
Judge, as I understand it, this case is not specially set on the 15th. We're just on the priority list for that day. So if we're specially set,
I'm sorry, lawyer. I'm still having a heck of a time hearing you. You obviously are explaining what else is going on in terms of the settings, and I would.
Judge, can you hear me now?
So yes, sir.
Okay, Judge. From what I understand, the November 15th trial date is not a special setting for us. It's just
okay. That's what I needed to find out, because I'm as an outsider, I need to try to minimize avoidable expenses for the local government over there. The commissioner's got other things they need to spend money on, and like roads and getting votes and so forth.
Judge,
is there anything else? Do you want to leave it? Do you want to put a final pretrial date in or not?
Yes. I apologize, Judge. Both the prosecutor here and Judge Martin just informed me that it is specially set for November 15th. So that is the date that we're going to go.
Well, I understand the trial date. What I'm talking about is a final pretrial. If there's anything else we need to work out. But a special set, would I infer that means that there are no other cases set that day? other than we're just number one?
That's correct, Judge.
If you want a pretrial date, you could go 12th, 14th of October, or you could do the 9th of November.
Judge Chris Martin has told me that we can do the 12th or 14th of October for final pretrial, or the 9th of November for final pretrial.
What'd you say, October 12th, what?
October 12th at 9 a.m. or October 14th.
Madam District Attorney, does that work for you?
Yes, Your Honor, October 12th or 14th is just fine.
Okay. And we're doing that at 9?
Yes, Judge.
Okay. When we get a little closer to it, we can figure out whether that's going to be another Zoom or whether that's going to be real. If I'm going to hear testimony, I'm still pretty much of the old school and prefer to have live witnesses that I can look at. Okay, anything else that we can do? Incidentally, on that jury selection, I thought that the panel came in earlier than that, than Van Zandt County.
Judge, typically the panel comes in around 8:30, 9 a.m. and the court qualifies them. And
okay, well, given the fact of the Judge Martin's recusal, I've got to be the one that qualifies the panel. So what amounts to, I'll show up at 8:30. If counsel, if you want to be present and hear the excuses and the beg-offs, well, you're welcome to be there. Otherwise, I'll see you at 9 o'clock. Hopefully at 9 or shortly thereafter, we could actually start the real selection of a jury.
yes, Judge.
Thank you, Judge.
Anything else that we can accomplish? I know Judge Martin has other business he needs to tend to.
Nothing from the state, Your Honor.
That's all from the defense, Judge.
Well, thank you very much, gentlemen. I'll see you back I guess at October the, whatever date that was, the 12th or the 13th. The 12th, 9 o'clock. Thank you.
Thank
Did you
you.
say October 12th?
Yes, he did.
Yes, sir.
Thank you, Judge Martin.
Thank you, sir. Good to see you.
I'm leaving the screen.
Okay. All right, who else is ready? All right, do you have the pretrial agreement? Yes, please. Thank you, sir. Yes, please. And he'll go to that podium right there in the back. All right, I'll need the attorney for the state to sign the waiver of jury trial. All right, Mr. Lopez, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Lopez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Raul Lopez, is that correct? And Mr. Lopez, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Warren Abrams. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss the case with him, have all your legal questions answered? Is there anything about this pretrial intervention contract that you've reviewed and signed that you do not understand? This would be the time. If there's something you don't understand, this would be the time to get it explained. Say again. You understand everything. Okay. And Mr. Abrams, have you gone over the pretrial intervention contract with your client? And have you explained to him his legal and constitutional rights that are derived thereunder? And you believe that he's competent today to enter into this contract? And Mr. Lopez, do you understand that by entering into this contract, if the court approves it, that you're waiving some very serious rights? You understand that you would be waiving your right to a jury trial in this case. That means if you enter into this program and you do not successfully complete it and you're placed back on the court's docket and we proceed to trial, you understand that that trial would not be before a jury of your peers. It would be a jury before the bench. You understand that your right to a trial by your jury of your peers is a right that can't be taken away from you. You understand that that's guaranteed to you by the Constitution. And are you telling me that it's your voluntary intent that you want to waive that right to a jury trial today to enter into this program? Right. The court will find that the waiver of jury trial has been intentionally, knowingly, and voluntarily entered into and consented by the state, along with counsel for the defense, and the court will approve the waiver of jury trial. Mr. Lopez, you would also be waiving your right to a speedy trial, and there would also be a waiver of right to expunction for certain records. You understand that by entering into the program, you would not be able to expunge the records of the Van Zandt County Criminal District Attorney's Office or the Van Zandt County Community Supervision and Corrections Department. You understand that? Those records will remain. Right, and I see here that the proposed term for this pretrial intervention agreement is for a period of 18 months on the charge of possession of a controlled substance in penalty group 2 greater than or equal to 4 grams, but less than 400 grams. And has the pretrial intervention program fee been paid already? Okay, just this thing here says it's got to be paid before you enter into the agreement. So is that the agreement?
Judge, as long as it's paid before the end of business today, the attorney's office believes that condition is.
And Mr. Lopez and Mr. Abrams, you are stipulating to the admission of the evidence in this case that's been attached to this contract?
Yes, sir.
All right, the court approves the placement of the defendant on the pretrial intervention program through contract. The court hereby approves and signs the contract. right, Mr. Lopez, I've signed the contract, so I'm gonna have you come forward and you'll meet with the Van Zandt County Community Supervision and Corrections Department over here through the store, and they'll give you additional information about the next steps, okay?
Thank you very much.
Thank you, Mr. Abrams. Mr. White, are you ready?
Yes.
Are you ready on, sir?
Harold, please.
Claudia Cook, CR 20153. Ms. Cook is set for docket call.
Your Honor, we're going to resolve this case. Soon this evening. What's your earliest one?
In September. September 16th. And so so we're setting this for a plea. What's the plea going to be? All right, court sets Ms. Cook to enter her plea before the court on September 16th at 9 a.m. All right, and I think I said for the record, if not, Jeremy Reeves, waiver of arraignment, e-filed approved, pretrial set 10/14. Thanks, sir. Yes. Record, no record.
Just a schedule.
Mr. Harden, are you ready on Mr. Sistrunk? Yes, Tanner Sistrunk, CR 21-189. Just come right here to this middle podium. Mr. Sistrunk set for pretrial today. Maybe you'll keep that and you'll just fill out those dates at the bottom there when we discuss that. Any contested pretrial motions? Well, here, go back to the podium so that we can pick you up on the audio.
We need to reset the pre-trial judge. Y'all have changed the discovery form.
The DA, I don't control discovery, so the DAs, so tell me again.
They agreed to a reset.
Judge, since Mr.
Harden.
Since Mr. Harden has been from last week, changed discovery, is not been set up our discovery portal. I given him how we set that up. Obviously, he doesn't have discovery yet. State's not on discovery set.
Okay, court will set Mr. Sistrunk then for pretrial on September 16th. And that'll be at 9 a.m. Mr. Sistrunk, after you get your yellow notice here with the dates on it, then I want you to report to pretrial release over here. They're gonna have some paperwork for you. You're gonna have conditions of pretrial release attached to your bond in this case. Okay. So once Mr. Harden has you sign that, then just, you can step on around this way by the TV and meet them through the store back over here. Is that all you have, Mr. Harden? And then you can just throw that one right there, Mr. Harden. Yes. Is it Puente?
That's my car.
That's- okay. Yes.
Here on Carlos Cabrera also.
Mr. Cabrera? This is CR 21-207. Does Mr. Cabrera speak English?
No, Your Honor, you require an interpreter for a formal arraignment. I can file, a waiver arraignment today, please support.
Do this, step back to my indigent defense coordinator. There's a hard copy. If you'll go ahead and go over that, she can give you a date. And then you can file, you can bring it back in here and leave it with me. And then that way you don't have to go through the e-filing process. He can sign and get a copy and get his date today.
Perfect. Thank you.
Ms. Thompson, are you ready?
Troy Burgess.
Troy Burgess? Mr. Burgess? I'm not sure that Mr. I've not seen Mr. Burgess today.
I haven't seen you, Your Honor. I didn't know you had to be here because I'm saying the letter.
And today we were going to discuss the status of his competency report, which he was found
And
competent.
You were found competent.
Okay, I guess we're going to hold Mr. Burgess's bond insufficient for failure to appear today. Okay,
My other case, Your Honor, maybe we filled out the paper, wait for some other stuff we filled out. And we'll be ready for that.
okay, great. So he is here.
Yes.
All right, thank you, Ms. Thompson. Yes, sir.
Mr. Mage, this one.
He's in jail. Yeah, but we've not been doing that. We've not been taking bail people and putting them in the afternoon. So maybe check with the states. Check with the state and see if they know anything that I don't, or check with Patty. I'm not aware of it. Doing great, sir. How are you doing today?
I was just telling the prosecution, last time I was here, I was negotiating with you. And I walked in and I said, you on the fence.
I hope it went well.
Oh, yeah.
Good, good,
You were reasonable.
good, good. I try to be more so now.
I appreciate it.
Good morning, Mr. Wood. Can you hear me, Mr. Wood?
Yeah, I can hear you. Can you hear me, Judge?
I can. I know your case is just a status, so I was gonna call you and get you in and get you out. Let's see. You also have, Johnny, you got Aaron Blevins, and Mr. Blevins is here. Let me call Mr. Lopano and we'll get that one out of the way. This is CR 2396, A versus John Anthony Lopano, still in custody in the Cameron County Jail. Any updates for the court, Mr. Wood?
Judge, I've been trying to reach out, get a hold of him to see if we can't schedule a meeting with him via Zoom or something along those lines, and not been successful. Obviously, we just got back I was out for a week, so I'll follow up with Diana to see if I get any headway on that front. Obviously, once I talk to him, I'll, get a better idea of what plan is over there, and then get with Ms. Heisel about how we want to resolve this case over here in Van Zandt County. So it's on my list to try to get things done on it, but at this point, I'm still working on that process, Judge.
All right, court's going to set Mr. Lopano for another custody status on, are you available on October 12th?
Yes, sir.
Okay, October 12th then. Aaron Blevins, Mr. Blevins, if you'll come forward, this is CR 16. Mr. Blevins is present in the courtroom and set for motion to revoke, Mr. Wood.
Judge, Mr. Blevins hired us last week. So we filed a motion, I think, to continue this to more detail.
And Mr. Wood, no, your connection's not good. So we're not getting much of what you're saying.
Okay, Judge, can you hear me now? I'm at the office, so.
Yes, I can hear you.
Should be.
Whenever you started to make your announcement, we lost you.
I said, Your Honor, I said that Mr. Blevins hired us last week. We filed a motion to continue this particular hearing today so that I could have an opportunity to talk with him in a little bit more detail about what's going on. In addition to that, talk to Ms. Heisel about ways in which maybe that we can resolve this. Mr. Blevins is out. Obviously, he's still on probation. He's reporting to probation, from my understanding. And so we're just asking for an additional, say, 30 days so that we can wrap our minds around.
Objection from the state. All right, so what I'm going to do, Mr. Wood, is I'm going to set him, I'll give you the 30 days. I'm going to set him on the contested docket on October. Actually, let's look at September. We'll set him on the contested docket on September 30th. So that'll give him the 30 days, but also gives him a deadline. That way, if there's no agreement, then there'll be a resolution on the 30th.
September 30th, Judge?
Yes, sir. September 30th at 9 a.m. And so if there's no agreement by that time, then we'll
That's perfect.
on the state's motion. So the bailiff has provided him with his notice and he's free to go.
Okay. Thank you, Your Honor.
Thank you, sir. Is that all you have today?
I have Jay Bruner this afternoon, Judge, and we're just gonna be needing to put him on the docket, on a docket call for that. So
Okay.
I think Mr. Woodwright and I would like to probably
Yeah, we're not, and I'm sorry.
talk to you about that one. And so,
Yeah, and I'm getting about every third word. So we'll try it again this afternoon.
all right, sounds good, Judge. Thanks.
Thanks. Ms. Thompson, are you ready again? Stuart Haywood, CR 21-122, CR 21-149. Is Mr. Haywood entering a plea today? Who has that paperwork? Do I have that paperwork? Yes, please. Thank you. All right, Mr. Haywood, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Haywood, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Get your paperwork organized here. Mr. Haywood, are you a United States citizen?
Yes, I am.
Do you read, write, and speak English?
Yes, I do.
Have you ever been diagnosed with any type of mental condition?
Yes, I have.
And what is that?
PTSD and night terrors, sir.
Okay. And are you currently undergoing treatment or medication for those?
No, sir.
Okay. Do you feel like those disorders are causing you any trouble and having a rational understanding of the proceedings here against you today?
No, sir.
Okay. And in this case, you're represented by your attorney, Miss Ann Thompson. Are you pleased with her representation of you?
No, sir.
You're not? Okay. Can you tell me about that?
Madam, I have problems asking questions, and it seems like it's her way to know. I feel disrespected. I mean, I just didn't like her entirely.
Are you still wanting to go forward with the proposed plea today?
I was ready to leave. I don't have a choice. It's either this or jail.
Okay. All right. So I'm going to recall your case in a moment. I want you and Ms. Thompson to speak again. And if you can't make any, well, so what I'm going to do then, Mr. Haywood, is I'm going to reject the plea agreement because it sounds like that you believe that you're under duress and that you.
It's not the rest situation, sir. I have questions about signing the papers because I let her know I saw the fine fee. And the biggest problem I have is I'm disabled. And I only get $500 a month. And I was asking what happens if I can't pay these fees? Am I gonna find from jail anyway or not? To me, these are like responsible concerns to ask, considering the fees. And I was asking her, what can I ask the judge? It makes out. So I mean, I'm gonna take responsibility for what is done and accountability because I don't want to be rid of it. I really.
Well, I understand that, but here's the problem. Here's my job. Okay. My job is to ensure that you know what your rights are and that you're being afforded representation and that you're making a voluntary decision today and that you know the consequences of your decision. And so you've already stated that. Well, no, I know, but listen, hear me out. If you stand there and tell me you're told it's either jail or probation, those are not the only options. You can go to trial. You could have a jury of your peers. You can cross-examine the state's evidence, cross-examine the state's witnesses. They could find you not guilty. They could find you guilty. You could ask them to assess punishment if found guilty. You can ask me to assess punishment if found guilty. So there are other options other than just plea agreement, either go to jail or take probation. So right now, that's what I've heard you say, is that you believe that there's only two options. And so when I say it sounds like you're under duress, well, if that's your belief at this time, then you've not been given full information, or you're not receiving the full information, or you're refusing to accept the full information and make a decision based on that. So, well, I'm gonna recall your case in a minute, because I've got 60 other cases I got to deal with today, and I'm not gonna be able to deal with you right now. So go ahead and have a seat. If you and Ms. Thompson want to talk more about it and see if y'all can get over this hurdle, great. If not, I'll take you up at the end of the docket. Okay, so I'll recall the case in just a moment. I understand. I'm gonna recall them. I need to get these other cases handled. Mr. King, are you ready?
Yes, Your Honor. Point out our paperwork.
Yes, sir, I do. Mr. Chaparro? All right, Mr. Chaparro, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Give me just a moment here. All right, let me look through this. So the proposed plea is that to the third degree deadly conduct discharge, he's going to be pleading guilty with punishment being assessed at 4 years TDCJ, concurrent with the other charge of deadly conduct discharge of firearm. So both 4-year sentences running concurrent with fines and costs. Is that right?
That's correct, Your Honor. We're gonna do 1245 on a,
I see that. Oh. All right, Mr. Chaparro, first question out of the box for you is, are you pleased with Mr. King's representation of you? Okay. Are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? And you feel like you've had enough time to go over your cases with Mr. King and have all your questions answered? Is there anything about the paperwork, your plea agreement that you've discussed, that you've read and signed that you do not understand? Mr. King, do you believe your client to be competent today?
yes, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor.
Mr. Chaparro, in cause number CR 2111, you are charged by indictment with a third-degree felony offense of deadly conduct discharge of a firearm, and that is also the same charge in CR 2112.
Your Honor, if I may answer that, he's actually tried with aggravated assault, and each of those charges. It is the plea agreement at the interim plea to the third degree deadly conduct discharge of a firearm.
That's correct.
So they're lesser included?
Yes, Your Honor.
Okay, that's not reflected here, so.
Would you like the judgment to reflect, I just don't know the weapon and terms to reflect lesser included deadly conduct? We were under the impression that you wanted the top to say whatever the act.
Yes, that I do. Yes, I do. Usually it's in the terms of the plea bargain, it's plea to the lesser included offensive, but that's okay. We'll just, as long as TDCJ will take it. Because they're going to be reviewing the indictments as well. All right, so you're charged by indictment with a higher charge of aggravated assault with a deadly weapon in CR 2111 and 12, but the plea today would be to the lesser included offense, a third degree felony offense of deadly conduct discharge of a firearm. The range of punishment for each one of those charges, that being a third degree, is confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Do you understand that full range of punishment, Mr. Chaparro? So I see here that the proposed plea agreement is that you're going to plead guilty to those in exchange for the state's recommendation and agreement of sentence at 4 years confinement in TDC with restitution and fines. And I find that that fits legally within the range of punishment. So you understand the plea agreement in this case, and you understand the range of punishment. Is that right, Mr. Chaparro? All right. So Mr. Chaparro, to the charge of deadly conduct, discharge of a firearm that occurred on or about October 31st, 2020, how do you plead? Pleading guilty? All right, make sure you speak up loud enough so my court reporter can hear you. And are you pleading guilty to those charges, Mr. Chaparro, because you are guilty of committing those charges? Has anyone threatened, forced, or pressured you to plead guilty? Court will accept a defendant's plea of guilt in each cause respectively. Mr. King, any objection to states one, stipulation of evidence?
No objection, Your Honor.
All right, states one is admitted and court takes judicial notice of the defendant's judicial confession in each case. Anything further from the state?
Yes, Your Honor, there is a decision statement in regards to this clause recorded to the court that they asked to review that.
The court has reviewed the victim impact statement. I find not much information included in that statement. Does the state have any additional information with regards to whether the victim approves or disapproves of this plea agreement?
Your Honor, the victim in this clause indicated to us that he understood the age of the defendant, and because of that, his main concern with the agreement was the restitution, which is included in the judgment over any particular resolution.
Thank you.
Judge, I would advise that both families to go ahead and try to pay that full amount, by restitution and the cost of each matter. Mr. Chaparro is incarcerated, not waiting for that months out. So trying to take care of stuff.
Thank you, Mr. King. Do appreciate that. All right, I'm gonna take a moment just to review the evidence. Deb. Yes, Mr. Earlier, if you'll go up and do that. All right, based on the court's review of the evidence, court will follow the plea agreement in this case. Court finds sufficient evidence to convict Mr. Francisco Lorenzo Chaparro of these offenses. Court convicts him of the third-degree felony offense of deadly conduct, discharge of a firearm in each case. Court assesses his punishment at 4 years confinement in Texas Department of Criminal Justice. Court will order these sentences to run concurrently. Court also orders in CR 2111 restitution in the amount of $2,140.95. Court also finds that the state is pressing the court to take into consideration CR 2113 under section 1245 of the Texas Penal Code, evading arrest with motor vehicle. Court also assesses court cost of $290 in each case and $35 reimbursement fees in each case. And the court awards Mr. Chaparro 2 days credit time, 2 days jail credit for time served previously in this case. right, Mr. Chaparro. Court has pronounced sentence and you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward here with the bailiff to be fingerprinted, and then you'll be taken into custody. Is that all you have, Mr. King?
All I have, Your Honor.
Yes, sir. Thank you.
Thank you, Judge.
All right, who's ready?
Madam Clerk?
Yes, who's your client?
Yeah, Keith Thomas, Your Honor.
Okay, Keith Thomas, CR 21-192. Mr. Thomas, if you'll come forward, sir. Mr. Stevens, if you'll slide out of the way so Mr. Thomas can see the court, it's okay. All right, Mr. Thomas is set for pretrial today.
Yeah, he is, Your Honor. I have had an opportunity to speak with the state. They have uploaded some discovery, to my understanding. There's also some media that I need to obtain. We talked and they were agreeable that we could reset this for pretrial, another pretrial for so allows.
Okay. Do you have your schedule with you?
I do, Judge.
If you'll go ahead and get that out, and let's make sure that we don't double book you. Look at September 28th for me.
Yes, sir. Now, September 28th, I have a setting in a pretrial setting in Wichita Falls.
Wichita Falls. What about October 12th? Well, and what about if we went back and looked at the 28th, what if, could you appear via Zoom? If we set you at a different time, how long do you think the hearing would last in Wichita?
The schedule is 9. If the court wanted to do maybe 11 o'clock, I could do that.
Okay, you wanna do that? Let's do that. Let's do that. I think that'd be better. So we'll set Mr. Tom, and Mr. Thomas will appear in person. But Mr. Todd will appear for pretrial on September 28th, and we'll do that at 11 via Zoom. All right, and so once he gets that yellow copy, if you, the white one can stay here, the yellow one will go to Mr. Thomas. And then Mr. Thomas, I need you to report to pretrial release. I'm gonna have conditions of pretrial release attached to his bond.
Yes, sir.
Okay, so Mr. Todd, if you need more information about that, they can give you more information, give you a copy of that.
Thank you.
So Mr. Thomas, you can come on around. All right. You ready on Jamie Nail? Jamie Nail, CR 21-29. Let's let her get up here so she can be involved. Mr. Stevens. All right, Miss Nail is set for docket call today.
Yes, Your Honor. Defense is requesting another docket setting. He is agreeing, so while we're really close to reaching a resolution to the case, we got asked about a few more things. We recently got a pretrial contract on Friday, so we can really need to help with that. We're really close to reaching some resolution before.
So the offer at this time is a pretrial intervention.
Yes.
All right, I'm gonna set Ms. Nell then for a final docket call on September 28th. Do you have any scheduling conflicts that day?
I do like. Next one's hearing out.
And where?
Well,
What time is that? No, we don't have criminal on Monday. October 12th. All right, Ms. Nail, you're ordered back before the court for docket call, your final docket call on October 12th. If you do not have an agreement reached on that day, then the court will put you on the jury trial docket. Once you get your yellow copy, you'll be free to go. Is that all you have today?
Yes.
Thanks, sir. Chanel, are you ready? Well, I don't need sorta, I need ready. Is he, I know he's positive for COVID, but is he ill? Is he- And that's confirmed. Okay. All right, then we'll reset Mr. Riddle then for docket call on September 28th. Do you have any conflicts on that day? Okay, we'll set him then and. This afternoon? Okay, thank you, sir. Good morning, Mr. Ashworth.
Morning, Judge. How are you?
Doing well. I appreciate your patience this morning. We got a little slower start than we
No
anticipated.
problem.
Let me go ahead and call your case and we'll get you moved on here.
Okay.
This is CR 2349 State versus Carlton Mitchell. I show that he's still in custody in Smith County. Any updates for the court?
He's got a setting on September 27th.
And do you know what kind of setting that is?
They're calling it an arraignment setting, Your Honor.
Okay.
And then there's a pretrial after that.
Can you remind me what he's charged with in Smith County?
It's a drug case. It's a state jail felony drug case.
So he has a state jail there and first degree here. Is that correct?
Correct. Correct.
And state, are we looking to bring Mr. Mitchell back on some type of bench warrant? Or are we going to let Smith County continue with a state jail? Does he have any other charges in other counties?
No, Your Honor.
Just those two?
If we can just get a reset date, I would.
Mr. Ashworth, are you available on October 12th for a custody status?
Just checking. Yes,
Okay. And are you representing him in Smith County?
I am.
Okay. Okay. All right. Then we'll set him for custody status on October 12th at 9 a.m.
Zoom again, Your Honor.
That Zoom is fine for you. Yes, because he's likely still be in custody. So there's no sense in you having to drive over. Just tell me that.
I appreciate it.
You're very welcome.
Thank you.
You're welcome. Have a great day, sir.
You too.
try to bring Mr. King in here. Mr. King, can you see and hear me okay? Right here, I'm gonna have you unmute there. Miss Weed?
Can you hear me, Judge?
Yes, I can hear you now.
I'm sorry, I got up for 2 minutes.
It's okay. Can you do me a favor? You have a jacket there in your office?
I do, yes, Your Honor.
Can you grab that for me?
Let me just get it.
Can you see that, Miss Weed? Thank you, sir. I appreciate that. All right, this is cause number CR 21197, State versus Heaven. Is it Leanne? Leanne Weed. We're set for pretrial, and Miss Weed is present in the courtroom. Miss Weed, if you'll raise your hand so Mr. King can see you there. Okay. And I've got you broadcasted on the television. So Miss Weed, your client, can see you as well, Mr. King. Are there any contested pretrial motions in this case? Motions to quash, motions to suppress, anything contested?
No, Your Honor.
Okay. You just want the court to set this for a docket call and let you to continue negotiating with the state. And so typically what this court does is we go from arraignment to pretrial. If there are no contested, then I set it for a docket call. And it's between that time, pretrial and docket call, that I expect the parties to try to resolve the case if we can via plea agreement. And if we can't reach a plea agreement by the docket call date, then I place the defendant on a jury selection docket or a bench trial docket, and then I don't accept plea agreements after docket call. So if you have your calendar, what I would do is I would propose that we reset this case to September 28th for docket call.
That works for me, Judge.
Okay, so Ms. Weed, I'm going to order you back before the court on September 28th in person. And Mr. King, do you anticipate appearing in person on that date?
I do, Your Honor.
Okay. All right. So we're going to have her, just a moment. We're going to have her fill out a notice of appearance for that date. She has raised her hand. Is it a question for your attorney or for the court? August 26th in which court? This court? You have multiple charges? What do you have in this court on Thursday?
Judge, if I may, I believe she's scheduled to check in with probation this Thursday. So I can't hear what she's saying, but I think that her question is, can she check in with probation today? I was going to talk to her after this and see if we could arrange that, rather than, she made quite a drive today to be there this morning.
So what I'm going to do, Ms. Weed, is I'm going to have you come over here and meet with the community supervision office, and they'll give you information on that. Okay. So, but you don't have a court date. You may be scheduled to meet with them, but you don't have a court date on the 26th. Okay. So your next court date will be September 28th that you're due back in this room. Come over here and meet with the officers, and they'll see if they can resolve that issue about you having to come back on Thursday. Okay. All right. You got your notice? All right. You're free to go. Step over here and you can come around and speak with these officers. Thank you, Mr. King. I appreciate your patience.
Thank you, Your Honor.
Have a great day. Bring in Mr. Kennedy.
Good morning, Your Honor.
Good morning, Mr. Kennedy. How are you, sir?
Good. I appreciate you accommodating me today via Zoom. I know that's a hassle.
Oh, it's okay. For this type of hearing, it's not a problem. Let me get your client up here. Mr. Hanselka, CR 21-169-170. How do you pronounce your last name? Okay.
I think you did it, Your Honor.
I'm butchering it. I don't mean to do that. All right, this is CR 21-169-170. We're set for pretrial today. Mr. Kennedy, have you filed any contested pretrial motions?
We don't, Your Honor. I spoke with, we don't have any contested pretrial issues to speak of. I spoke with the prosecutor on the case last week, we're trying to come to potentially a plea bargain on this case, but we're working towards that. So we weren't going to take up any pretrial issues today. We were hoping that we could just get on the docket. I understand you guys do a trial docket. Is that correct?
Well, typically what I do is we go from arraignment to pretrial, and then I set it for what I call a docket call. And it's between pretrial and docket call that I hope that if a case is going to resolve, that it will be negotiated and resolved in that time. But what your client will need to know is if we set a docket call and we move past that with no agreement, then I'll place you on the trial docket, but I'm not going to accept a plea agreement after that other than an open plea.
Understood, Your Honor, and that was my understanding as well. So yes, if we could just place on the docket at this point, we're gathering some additional information for the assistant district attorney there. So,
okay, do you have your calendar available?
I do, Your Honor.
All right, we look at September 28th.
Your Honor, I'm actually in September. I'm actually on a hunting trip on the 28th. I don't know that I got my vacation letter filed in this court, so I apologize for that. But I'm out of town that week. But October is pretty clear, with the exception of some trials.
Hang on, I think I gave you, okay. So what about September 30th? I gave you the wrong date. I said September 28th. Are you still on that trip on the 30th?
Yeah, that's when I get back.
Okay. What about October 12th?
Well, should work just fine, Your Honor.
All right, we'll set Mr. Hanselka on October 12th at 9 a.m. We're going to have him fill out a notice of appearance, give him a yellow copy with the date on it, and then he'll be free to go.
And Your Honor, I am set for a trial on the 12th, but it's in Dallas County, and it's my understanding that those, it's a civil trial. It's my understanding those are not going to move forward. So,
yeah, I'm not sure, but probably not likely.
Yeah, unfortunately. So,
okay, all right, free to go.
Thank you, Your Honor. May I be excused?
Yes, sir. Thank you. Yes, sir. You're free to go. Have we verified more? Should vote. Confirm that for me. The indictment or the arraignment? I don't know why. Just go back to the document. Mr. Stevens, are you ready?
Yes, sir.
Is Dakota Dubose here? I called Mr. Dubose and Misty Rice. So CR 2133, Ms. Rice is set for a docket call today.
Yes, Your Honor. We're going to ask for one more docket call. This, I know the docket, this is the second one already. However, that's docket call. She had symptoms remaining unbelievable. That did receive a good offer from the state. And I discussed it with my client, it would probably result in a plea, but she wanted another court saying that the court would do it. So she is with her family.
What's the new offer?
The new offer, Judge, would be, she was offered either a 2-year deferred on the felony, or today the new offer would be a 12-week for a convicted for a year, suspended for a year. So that's the new offer, Judge. Which was just got this morning.
So she's already had 2 deferred.
Yes, sir, the offer, the prior, the new offer, so 440 for a year suspended for a year.
And I guess my concern is that she's had 2 probation offers. What's significant about the new offer that she can't put her mind around today?
It would be a shorter probation period. The county.
Right, I'm saying what's, and I'm sorry, I can't hear you, but
It's really hard.
no, I understand. No, it's okay. And I really want to hear from Mr. Stevens, and
So that's why we're asking for another docket. I didn't want to get to the trial docket, we try to make a deal with the docket check.
state.
Judge, state's unopposed to another docket call. We also be unopposed to placing on the trial docket and leaving our offer open for a very limited period of time, about a month, once she can get on docket call. And she'd like to resolve it within that time frame, if the court is comfortable doing that. General policy is that we revoke offers at the time we place a docket call. I'm willing to give her the flexibility to accept these offers. Mr. Stevens brought to me, Ms. Rice is requesting a shorter period of probation. We figured out a great way to give her a shorter period of probation. But obviously there are downsides to that as well. Obviously, also shorter period of probation for financial obligation per month would go up. There are a number of things that I think she does need to consider. I would really offer her that kind of flexibility. However, the court would like to.
Do you have your schedule with you, Mr. Stevens?
I do, bro.
September 28th.
You're already.
All right, so Ms. Rice, I'm going to reset you so that you can make a decision on what you want to do. If there's no decision made, then it's going to be a rejected decision on the 28th, and then I'm going to place you on the trial docket, and there will be no plea agreements after that. Yes. William Robertson, CR 21-142. Mr. Robertson set for pretrial today.
Yes, Your Honor. We have no formal pre-trial papers.
All right, court will set Mr. Robertson then for docket call on September 28th at 9 a.m. Mr. Robertson, I don't know if you made any payments today towards your pretrial release, but I show there's a delinquency. So I want you to report over here to pretrial release and talk to them about making a payment and trying to rectify that, okay? I'm sorry, this is also CR 21-151. Also set for docket call on September 28th. Tracy Smithhart. This is CR 21-145 set for docket call.
That's correct, Your Honor. We have waiver of jury trial.
Is there an offer already?
Yes, sir. We do have an offer. It's going to be reduced to 1244A with about 3 weeks. We're just trying to get our schedule.
All right, Ms. Smithhart, if you'll raise your right hand, I'm going to place you under oath. Ms. Smithhart, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Ms. Smithhart, you're represented by Mr. Stevens. Are you pleased with Mr. Stevens' representation? Feel like you've had enough time to discuss this waiver of jury trial with him, and do you feel like you understand it? You understand that you have a constitutionally guaranteed right to a jury trial of your peers? And during that trial, you can cross-examine the state's witnesses, you can confront their evidence against you. You understand that if you waive that right to a jury trial, it may not be restored to you under just very limited circumstances. And has anyone threatened, forced, or pressured you to waive your right to a jury trial today? All right, the court will find that the waiver of jury trial has been signed by the defendant, Mr. Stevens, counsel for the defendant, and the attorney for the state. Court hereby approves the waiver of jury trial. Can we set her for the plea on September 28th as well?
Yes, sir. Absolutely.
All right, Ms. Smithhart, we'll see you back for plea on September 28th at 9 a.m. And Ms. Smithhart, before you leave, I want you to report to pretrial release, okay? Ronald Toll. CR 21-146. Mr. Toll is set for pretrial.
Yes, Your Honor. We have no formal pretrial matters.
All right, court will set Mr. Toll then for a docket call on September 28th. Has Mr. Toll been extended a plea offer?
Yes, Your Honor.
Okay.
The plea offer is, there's been a couple of different offers. Like one's a 4-year term, Your Honor. One is 2 years, 2 years state jail probated for 3. So we're kind of pondering which way we want to go.
Thank you. All right, Mr. Toll, we'll see you back on September 28th. After you sign the notice of appearance and get the yellow copy, I'm going to have you placed on conditions of pretrial release. So I'm going to have you come over here and report to the officers, and they'll give you further instructions. But he's going to bring this to you, give you the yellow copy. After that, and you'll report over here. I'm gonna try to bring Amy Harmon in.
Sorry.
Give you a moment where you can get nice and still. All right, this is here. This is cause number CR 21-121, State versus Amy Harmon. She is set for docket call today, and she's appearing via Zoom with the court's approval. Your announcement, Mr. Stevens.
I'm going to ask for another docket call. She and I have not get together because of COVID situation.
And can you hear Ms. Harmon? If you'll just approach here, Mr. Stevens up here.
Oh, sure.
Those microphones are not picking up.
No, Your Honor, we're going to ask for another docket call. We have not been able to get together and discuss the case in any detail because of her COVID situation. So we're going to ask for another docket call, Your Honor.
So how long has the COVID situation prevented y'all meeting?
One more time.
Well, I was asking Mr. Stevens, how long the COVID issue has prevented you and your attorney from meeting?
About 3 weeks. About 3 weeks. Since the last time I was at court.
She's been ill just about after the last court appearance.
Any objection from the state? This is our first docket call. She was indicted, arraigned in June, pretrial July.
No, Your
First
Honor,
docket call.
I was just making sure. No, we haven't.
All right, court's gonna set Ms. Harmon then for an additional docket call, and Ms. Harmon, you're to appear in person unless there is another reason that's provided to the court prior to that on September 28th at 9 a.m.
Okay.
So that this will be the only notice that you get from the court here in open court, you understand?
Okay.
All right, so we'll see you in person on September 28th at 9 a.m. And you're free
Thank
to.
you. Thank you. So I'm not good to go, or?
You're good to go.
I think that's it for the judge.
I think that's it. See. Mr. Crane, are you ready? Adrian Gutierrez, CR 2168, set for docket call. So have you done all your negotiations with the state?
Not really got very far. My time is in this.
Okay, so Mr. Gutierrez, what are the offers in the case? Just so that I'm aware. No offer from the state?
I also had surgery recently. It's happened the past couple of weeks. It's okay, having surgery again, shoulder. And that's like over there. But 60 to 90. He's blind, one eye, and so he already has somewhat trouble walking. So with his GPS monitor, I believe he's not violated at all.
Well, you need to file a motion and give notice to the state. Yeah. Yeah. Well, if you'll file a motion, give them notice, and then request a setting, then we'll put it on a day where we can take up evidence. State, no.
Looks like the state has not made an offer. State would make an offer 12 years. Today. That would be our initial offer. It's 3 years in my.
And Mr. Crane has announced for his client that you don't want to take any offer. Is that correct?
That's what he's told me, yes, sir.
Okay. I just want to make sure that if there was going to be an offer made, that it was on the record. So, all right. So, all right, there being no plea agreement in this case, the court will set Mr. Gutierrez on the jury selection docket, and we will begin that on next week on the 30th. Well, that's okay. You're not going to be required to be here. He's not going to go to trial. He's going to show up and receive his next setting, and he's not likely to go to trial this year.
Thank you, sir.
So you're not going to be required to be here, Mr. Crane, until you receive the court's notice that the case is liable for trial. And so, Mr. Gutierrez, you'll report in the basement of the courthouse around 8:30. And my staff will be down there, and they will give you additional information about your next court setting. They'll have a notice of setting. You'll sign it, check in, check out, and be good to go. And then you need to make sure that you're still in compliance with your pretrial release officer, okay? Yes, Monday.
Okay.
And you'll continue to do that until your case is reached for trial.
Okay.
Yellow copy is yours, white copy stays here. He's having the prosecutor sign it. He's going to bring it to you. And you're free to go, Mr. Gutierrez.
Thank you, sir.
Are you okay? Do you need a break? You okay? You need a break? All right, we're going to stand in recess for 10 minutes. 10 minutes. CR 21-147 State versus Samuel Adam Turner. Mr. Turner is set for pretrial today. Is that right?
That's correct, Judge. At the last pre-call, I asked the state for two things. The criminal history, including impacts, and the body camera of the blood draw from the CWI case on October 31st. I believe Mr. Woodwhite had requested both. I received the impacts online discovery, but I still don't have the body camera of the blood draw, Judge, if it exists. I don't have any pretrial issues because I believe all the enhancements are properly put in the indictment. And we can set it for a docket call for the body camera.
You don't anticipate any potential motions to suppress if you get the blood draw video?
If there is, Judge, I'll just file a motion to leave and then file it. I don't want to keep prolonging the court's time with that.
Okay.
Judge, for the court's record, I requested that about 2 weeks ago. I requested it again today. The DPS would very well make one more and there. But I will further make sure we turn that, if it exists, to Mr. Morelli here, so we can move forward.
You available on September 28th? All right, Mr. Turner, we'll set you for docket call on September 28th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Thank you, sir. I do appreciate that. Yeah, I've got a note here that that you've done that, and we appreciate it.
Thank you, sir.
You're welcome. Mr. Ashmore, are you ready? I'll tell you what, Mr. Ashmore, wait just one moment and let me bring Mr. Harrison in. I had him scheduled for 11. I just saw him here. Yes. Yes, I just brought him in. Yes, there is. Good morning, Mr. Harrison. Can you see and hear me okay? I'm not a good lip reader. I know you're still learning. I know. I understand.
This whole Zoom is new to me.
They're brand new. Still don't know how to work it. How are we this morning?
Frazzled. How's the course?
A little bit of the same. A little bit the same. I had a rocky start this morning. Had visiting Judge Banner was here, and so we had a little rocky start this morning. It's getting better though. It's getting better. Is Mr. Kostovsky, is that going to be a plea today?
Judge, it is. We have it worked out. He's in the courtroom.
Mr. Porstowski, if you want to come on up there, sir. Can you see Mr. Harrison here on the screen? All right, he said, let me go ahead and call this CR 13-323 State versus Richard James Porstowski. Go ahead, Mr. Harrison. Didn't mean to cut you off.
Oh, that's okay, Judge. It's a revocation, Your Honor. We've got it worked out with Ms. Curry. It's going to be a 4-day with credits for 4 days. He has back costs that he's got a check for today that he's going to pay. And it's under 1244A.
Are we doing this today or are we just, do you have the paperwork?
However, no signatures are on it. It's not filled out. I was not aware that Mr. Harrison was not appearing in person. So we didn't pre-arrange signatures. We could get mine and Mr. Portofsky's, and if Mr. Harrison does not object to me signing on his behalf or the court signing on his behalf, I'm not really sure how we want to facilitate that.
Have you already gone, Mr. Harrison, you already gone over the paperwork with your client?
Yes, Your Honor.
All right.
And I certainly don't have any objection to to Hillary signing my name. If I did know, I thought I had signed everything.
He doesn't have a copy of anything that's signed. Did you email that to them or how did that go? Because I mean,
We emailed it to Patty this week sometime. Last week, pardon me.
Okay, let's go check with Ms. Taberhan then. Okay, All right, let's do this. I'm gonna have your client just have a seat until we figure that out. I'm gonna call a couple other cases and then we'll get going again.
Yes, sir.
All right, Mr. Ashmore, are you ready?
I'm ready.
All right, who are you ready on?
Step three.
Kobe Heron, CR 18-263 and 2020-379. Yes.
More judge, we are step three on. The case. The state has offered and we agree to 2 years straight probation, both offenses. For you in just a second.
Okay. Mr. Heron, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Heron, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you? Feel like you've had enough time to discuss the case with him, have all your questions answered? Anything about the paperwork that you read and signed today that you do not understand? All right, and Mr. Ashmore, do you believe Mr. Heron to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, Your Honor.
Before we go any further, Mr. Ashmore, maybe you and Mr. Heron can tell me why I should approve this. Why am I putting him back on probation if he didn't comply with probation the first time and he committed a new offense while on probation? Why would I even do this?
Judge, this is a young man who knows he's given an opportunity for a deferred to not have a felony on his record. He has made a mistake. He's got involved with DWI in the middle of that probation sentence, jeopardized that, Second Amendment right, voting right, all that's out the window. He knows that. He does have a young family. As you can see, he's smashed his arm pretty good within the last year. He's currently working, has a good job. And this is really about keeping the citizen, paying taxes, paying the county back, and not filling up the county and costing the county by being just another body in the county jail or waiting on the rotation.
Well, I understand that, but I've got him on probation and he's drinking and driving. I'll put him back on probation today. What do you think that I think is going to happen, Mr. Heron? You're going to be drinking and driving again. Why should I not just lock you up, put you in prison right now to ensure that my family's safe and everyone else's family is safe? Why shouldn't I do that? I mean, the whole body and taxing and warehousing, that's lost on me. I'm looking for community safety here. And I mean, you knew what the consequences were. Why should I do that? I need to hear something more compelling than money and so how are you going to do it right this time? What's changed here that's going to make what you do different? And what does that mean to you, having your first son? My gut tells me not to do it. That's my problem. I've got 2 sons also. I worry about them because of people like you and drink and drive. Well, it says here that you're pleading guilty to it. So you were intoxicated. If you're telling me you're not, then this plea is not going to happen at all. Speak up. Speak up. Be a man. Speak up. I'm just telling you. We're just having a conversation here, me to you. That's who I worry about. And my 2 little girls. I don't want to get that phone call. I don't want any family to get that phone call. And I certainly don't want to be the guy that signs off on it. What's that?
Judge, maybe I could ask the court not to reject that deal. If it's a mistake about conditions court might accept. Make that public safety issue.
Well, for starters, do we have an interlock or a scram? Do we have anything like that?
Judge, it's not alcohol.
What was that? All right, Mr. Heron, I'm gonna go against my gut here. And I hope you prove me wrong. I would love to be proved wrong. Slightest misstep, and your baby's gonna be 2 while you're sitting in the prison. Understand? All right, Mr. Heron, and cause number CR 18-263. Is Mr. Heron going to waive the formal reading of the state's motion, Mr. Ashmore?
Yes.
He's going to plead true to all counts. In cause number 2020-379, Mr. Heron, you're charged by information with a Class B misdemeanor offense of driving while intoxicated. That carries a range of punishment of not more than 180 days confinement in the Van Zandt County Jail, and a fine not to exceed $2,000. You understand that full range of punishment? And I see here that the plea agreement is that you're going to plead guilty to driving while intoxicated, and the state's recommending that the court assess your punishment at 180 days and suspend that and place you on community supervision or probation for 2 years to run concurrent with your felony probation. In addition, you would have a fine of $200 and court costs of $270, reimbursement of $95. You understand that plea agreement as well? How do you plead to driving while intoxicated? Are you pleading guilty because you are guilty of that offense? Has anyone threatened, forced, or pressured you to plead guilty today? Cause number CR 18263, the state has filed a motion to adjudicate and revoke your community supervision. State has alleged in 8 separate counts, various ways that you have violated the terms and conditions of your community supervision. Mr. Heron, are those counts true or not true? And are you telling me that they're true because in fact they are true, that you did commit the conduct alleged in each one of these counts? All right, court will accept the defendant's plea of true to counts 1 through 8 as contained in the state's motion. Mr. Ashmore, any objection to states 1 in the DWI case and states exhibit A in the burglary building case?
No objection.
All right, states 1 and states A are admitted into evidence respectively, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense?
No.
Mr. Ashmore, I'll need Mr. Heron to sign his certification of appeal in this felony case. Okay, so Mr. Forstowski, okay, good. Can you take Mr. Forstowski and have him sworn while I'm doing this? All right, Mr. Herring, as I said before, I hope you prove me wrong. Congratulations on your son. I hope that you live in a way, not only that he's going to carry on your name, but you're carrying his name too, right? It's not a one-way street. Why don't you be someone that your son can be proud of, right? And you know what? You can make mistakes in your youth and you can fix them, you can correct them, and you can put them in your past. And that's what I expect from you, right? I hope that's what you expect from yourself. All right, Mr. Herring, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Come forward with the bailiff here, be fingerprinted, and then go with these officers over here. All right, Mr. Ashmore, who do you have next? Ms. Fowler, CR 2333-334. Show status on competency. Have we had a report returned?
Not had a report yet. The order's been signed. Or the state earlier, they haven't got it either. So my daughter's in contact with me.
be apprised. And we just don't know what the status is. We're asking for essentially a short reset, and if there's a number that I need to be getting after.
I'm trying to find my court's order. I don't see it in the case. You remember getting the court's order? Written order?
I understand.
I'm not sure that an order's been completed. See, we'll have a seat, Ms. Fowler, and we'll check on that in just a moment. Okay, I'll check with Ms. Taberham. It could be one that the court hasn't done the order, because I do the orders. Mr. Frericks, CR 2163.
Here on State of Frericks, we have an offer we just received recently to TDCJ, $2,000 fine for cost fees. And I believe this is a March case, so this may be our last.
I think we're set for pretrial.
Set for pretrial. At this time, we don't have any contested pretrial matters. We'd like an additional pretrial or docket setting so we can continue to work on this pre-offer.
Are you available on September 28th?
Yes, Judge.
All right, Mr. Frericks, you're set for a docket call on September 28th at 9 a.m. in person. I'll expect to hear some kind of announcement from you through your attorney on whether or not you're going to accept a plea agreement or request a trial. Damon Gutierrez? Is Damon Gutierrez here?
Thought he was in jail.
Thought he was in jail?
And I'm going to ask the court after we get the larger to let me have an opportunity to step out and call.
All right, go ahead and do that. I've got to check on Ms. Fowler, and I think that's the last one that I showed.
Mr. Smith is here.
Okay. DeAnthony Smith?
Do we have competency order?
Yeah, I think so. All right, and let's see here. Mr. Smith is set also for pretrial.
Yes, Judge, we have an offer. We've been working on with the state, paying deferred $3,500 fine for cost of fees. Maybe out of docket calls, Judge, we did recently get this offer.
I think I'm showing set for pretrial.
Oh, I thought I heard you say that. So forgive me for jumping the gun and running myself out of passage, Judge. I would like a docket call or pretrial setting so we can see if we're good to go on this offer. Allow Mr. Smith to see if that works for him and his family, or if we have any other room to negotiate.
All right, court will set Mr. Smith for a docket call on September 28th. Once you sign and get the yellow copy, you're free to go. All right, Mr. Harrison, I believe I'm ready on Mr. Porstowski. Let me see.
All right. Thank you, Judge.
All right, Mr. Porstowski, if you'll approach again. And Mr. Ashmore, you said you were going to step out in the hall. All right, give me just one moment here. We're back on the record, CR 13323. State versus Richard James Porostowski. Ezra, can I have you sign this on behalf of the state? Thank you. All right, Mr. Porostowski, I believe I placed you under oath earlier. Is that right? Did I have you swear? Okay, let's go ahead and do that then. Raise your right hand, sir. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Are you Richard James Porostowski?
Yes, sir.
Am I saying that correctly? Close?
Sounds right to me.
Okay, well, if it sounds right to you, then I'll go with it. All right, and Mr. Harrison, is your client going to waive the formal reading of the state's motion to adjudicate?
He will, Your Honor.
And is he going to be entering a plea of true to counts 1, 2, 3, and 4?
Yes, Your Honor.
Okay. And do you believe your client to be competent today?
I do, Your Honor.
All right. And Mr. Porostowski, do you believe that you've had enough time to talk with your attorney, Mr. Harrison, about this case and have all your questions answered?
Yes, Your Honor.
Are you pleased with his representation of you?
Yes, Your Honor.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, Your Honor.
All right, so at this time, I'm going to ask you, with regards to counts 1, 2, 3, and 4, as contained in the state's motion, sir, are those counts true or not true?
True from my understanding. What exactly are you saying?
It's okay. So the state has filed a motion to adjudicate and revoke your community supervision. It's a charging instrument. And so they've alleged in count 1 that you violated your community supervision by failing to report for the months of March 2015, April, May, and June of 2015. And then count 2 that you failed to pay your supervision fee for those same months. Count 3 that you failed to pay your urinalysis fee for those same months of that same year. And that count 4, you failed to successfully complete your community service restitution as ordered. Those are all true. Mr. Porostowski, has anyone threatened or forced you to make you feel like you had to plead true to any of these counts today?
No, Your Honor.
All right, court will accept the defendant's plea of true to each count. Mr. Harrison, any objection to State's Exhibit A, defendant's waiver of rights and plea of true?
No, Your Honor.
All right, State's Exhibit A is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state? From the defense, Mr. Harrison?
No, Your Honor.
All right, and I see here that the recommendation is that Mr. Porostowski's guilt be adjudicated, that his community supervision be revoked, and that his punishment be assessed at 4 days confinement in the county jail with credit for time served, with the balance of his financial obligations, money being due at the time of the plea. And so, Mr. Porostowski, are you prepared to pay the financial obligations today?
Yes, sir. Today.
Okay, thank you, sir. All right, then based on the evidence and the plea agreement, the court will follow the plea agreement in this case. Court finds that Richard James Porostowski has violated the terms and conditions of his community supervision. Court hereby adjudicates his guilt for the offense of possession of marijuana, 4 ounces to 5 pounds. Is that a felony conviction, Mr. Harrison, or was this a lesser included? I didn't pull up the prior judgment.
It's on the revocation, it's a felony conviction, sentenced as a misdemeanor, Your Honor.
Okay, so it's state jail and then it's gonna be 1244A.
Correct.
So the court convicts him of that offense, assesses his punishment, revokes his community supervision, assesses his punishment at 4 days confinement in the Van Zandt County Jail under section 1244A of the Texas Penal Code. Court will award him credit for time served. Court orders him to pay the balance of his financial obligations today, including a $1,778.66 fine, $119.34 court costs, that being due today. Court hereby remands him to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. All right, so I'm gonna have you come forward to be fingerprinted, and then you'll need to step across the hall and pay your fines and fees. Just stay right there. Bailiff's gonna fingerprint you in just a second. I think I'm not letting know. All right, is that all you have, Mr. Harrison?
It is, Your Honor.
Thank you, sir. Appreciate it.
Thank you. Thank you for having me, Your Honor.
You're welcome. All right.
Judge, I would have been happy to appear in person, but as you know, Mr. Files came down with COVID and I had a contact with him.
Okay, no, I wasn't.
Trying to stay away.
I wasn't aware of that. Is he doing okay with it?
He's doing well. He's tired and has a cough, but he was fully vaccinated, so he's doing well.
Excellent. Well, that's good news. Tell him I look forward to seeing him again.
Will do. Thank you, Judge.
You too. Always on. I'll pull it up in here. I don't know that I saw it in e-file or not, so. All right, Mr. Ashburn. Ms. Fowler, if you'll step up. All right, we are back on the record, CR 2333, CR 2334. I'm not sure. I believe that the issue is I didn't receive a copy of your supplemental motion that I asked you to file, so I wasn't aware of it.
Oh,
So
I thought we thought maybe we had to e-file an order mistaken. If the court would do its own order anyway.
well, I think the issue is I didn't see the supplemental until today. So the order didn't precipitate it. So the court's going to grant the motion suggesting or the motion for competency evaluation. Court's going to appoint Honorable Timothy Ingram to conduct that examination. Court has signed that this day. So Ms. Fowler, just make sure that when Dr. Ingram contacts you that you respond to him and set up a time and location so that we can have you evaluated so that we can move forward in the case. Okay, so what we'll do is we'll set this. Today is the 24th. Are you available on October 12th?
Yes.
So we'll set this for competency evaluation on October 12th. That'll give Dr. Ingram some time to get this order today and start making arrangements. Need to remember this. Ms. Fowler, I want you to meet with pretrial release before you go. Okay. Did you give Ms. Thompson a copy of the indictment from Ms. Rash?
They got an updated distribution.
Yes, let's go ahead and hear about that. This is cause number CR 2169. Go ahead.
Judge called his mother and some confusion with communication from the bondsman. She put me in touch with him. He swears he called his bondsman yesterday. I haven't had time to vet that. I spoke to him and I told him, if he has any hope of saving his bond, he needs to get up here right now. And I asked the court to allow him to appear at Van Zandt County Jail. Of course, I'm on stage here. Shower.
You are thinking correctly.
So. Apologizes, he's very diligent. I'm sure on minute they would say that he called the bondsman, thought his date was not today, but Thursday, whatever information.
All right,
He's
well,
on his way now.
all right, well, we'll see him at 1:30 at the jail. Tell him to sit out in the lobby and wait to be called.
Yes, Judge.
And if you see him, then you'll let Deputy McLeish know. Yes, sir. Thank you. Look, will you approach? Bryce Carroll, CR 21208. Mr. Carroll, you have applied for indigent counsel. Court has reviewed your affidavit, finds you to be indigent. Court has appointed Honorable Casey Ashmore to represent you. You are going to be required to reimburse Van Zandt County for his fees incurred in this, and you're going to do that through conditions of pretrial release. You're going to have to report monthly. You're going to have to make payments for your reporting officer to supervise you, and you're going to have to make payments towards Mr. Ashmore's fees in this case. Do you understand? Okay. And so, Mr. Ashmore, I believe that we've provided you a copy of the indictment, and have you had a chance to go over that with Mr. Carroll?
I have it on it. And don't have a formal waiver of the indictment, but I have asked Mr. Carroll if he seen his name on the indictment. He has. He confirms it's spelled correctly. He understands that the offense is health and safety code violation, possession penalty group 2 of more than 2 grams greater than or equal to 4 of the substance known as tetrahydrocannabinol other than marijuana, the amount of 4 or more but less than 200 grams. So his name is spelled correctly on the indictment. He understands it's a second-degree felony. We pulled up the Texas statute on what that punishment range is, $220,000, $10,000 fine. He understands all that. Carrying forward and enter a plea of not guilty on my client's behalf at this time.
All right, court enters Mr. Carroll's plea of not guilty into the record. We would set for pretrial on October 10th. And so, Mr. Carroll, after you sign this notice of setting with your new date to come back, step over here to see the pretrial release officers, and they'll give you paperwork and more instructions, okay? Ms. Rash? All right, this is cause number CR 21-186 and CR 21-155. State versus Stacy Lynn Rash. Ms. Rash, the court has reviewed your application for appointment of counsel. Court has reviewed about 3 of those that you've submitted, and each one of them continues to be different. I've got concerns about that. So what I'm going to tell you is I'm appointing Ms. Thompson to represent you, but if I find out that you're hiding assets, that you're not disclosing relationships, if you and your husband are still together, he's supporting you, the family, if I find out that any of that is wrong, I'm going to personally take that over to the DA's office and ask them to prosecute you for tampering with a governmental record. We clear? All right, Ms. Thompson, I believe that we provided a copy of the indictment in this case.
Your Honor, we have received a copy of the indictment and also a copy of the information on the misdemeanor case. We have to sit down and review that together and they discuss correctly. She doesn't understand what she's charged with. We'll avoid the reading of the formal indictments and we plead not guilty.
All right, court will find that Ms. Rash has waived the formal requirements of arraignment. Court will enter her plea of not guilty in each cause, and the court will set Ms. Rash for pretrial. Are you available October 12th, or looks like October is either the 12th or the, I'm sorry, yeah, 12th or 14th. Do you know if you're coming back? Okay, let's set October 12th then. And that will be for pretrial. All right, Ms. Rash, once you get that, I need you to come back and check with a pretrial release. Make sure she has conditions signed. She should already, if not, but go ahead and come back here and report with them. And regarding Mr. Keith Mays, I called this case earlier. It's been brought to my attention that he, I believe, was informed by Ms. Beasley to report to the jail.
At 1:30, Your Honor, we're going to take a plea for time.
Okay.
So we agreed to do it at 1:30, same transport.
Okay. Is that something we discussed in court last time, or is that?
Your Honor, I think we did talk about playing for a plea. I think we didn't talk about
Okay.
doing that. I don't.
This is a brand new case. We filed information, so I think it's.
Okay.
But I don't think there was any last.
Mr. Haywood, come on up, sir. All right, before we go on the record, we'll be off the record. So have y'all had an opportunity to discuss? Are we ready to go? You comfortable? Are you happy with? And I should have said this earlier. A lot of times, you know, defendants and attorneys, their personalities don't always match, right? And what's that? Well, there's always an opportunity to grow, but I'm just saying that, you know, in this relationship, you know, you don't have to like one another, but there just has to be open communication. You know, she didn't have to like you. You don't have to like her. Y'all don't have to hold hands and go to Dairy Queen after this. There's none of that, but. Okay. All right. Well, I appreciate y'all working that out. All right, we'll go back on the record here. CR 21-122, CR 21-149, State versus Stewart James Haywood. Let me get my paperwork out here. Mr. Haywood, I believe I swore you in earlier, so you're still under oath, okay? And I think we stopped at that question when I said, are you pleased with Ms. Thompson's representation? And previously you told me no. And the court then recessed in your case, asked you to speak with your attorney, and now we're back on the record, and I'm going to ask you again, before I consider these plea agreements, are you pleased with the representation of you by Ms. Thompson? And you've had an opportunity to sit down and speak with her and She spent, she has indicated to the court that she spent a little bit more time going over, and has that satisfied any questions that had remained prior to this time?
Yes, sir.
Okay. And Ms. Thompson, do you believe Mr. Haywood to be competent today? And you've explained to him his legal and constitutional rights.
Okay.
All right. And so, Mr. Haywood, in CR 21122, you're charged by indictment with a state jail felony offense of possession of controlled substance and penalty group 1 less than 1 gram. That carries a range of punishment of not less than 6 months or more than 2 years confinement in that state jail division of TDC, and a fine not to exceed $10,000. I see here that the plea agreement that you want to enter into with the state is that you're going to plead guilty to that offense in exchange for their recommendation that your sentence be assessed at 2 years confinement, but that sentence be suspended and you being placed on community supervision or probation for 3 years with a fine of $1,900 and restitution of $180 in reimbursement fees, which includes Ms. Thompson's fee that the county pays for legal representation of $935. You understand that range of punishment in that plea agreement? All right. And in CR 21149, you're charged by information with a Class B misdemeanor offense of driving while intoxicated. That carries a range of punishment of not more than 6 months confinement in a county jail and a fine not more than $2,000. Do you understand that range of punishment? That means any punishment handed down by the court or jury would have to be within that range of punishment. And I see the plea agreement in this case is that you plead guilty on the recommendation for 180 days sentence suspended and you being placed on community supervision probation for 2 years, that being run concurrent with your other probation, and a fine of $100 plus court costs and plus reimbursement fees. So do you understand the plea agreement and the range of punishment in that case? And you understand if the court approves these today and I place you on community supervision, if you violate your community supervision, have you been on probation before?
Yes, sir.
Okay, so you understand how it works. You understand that if you go over on probation then and you violate, that the state could file a motion to revoke your community supervision, bring you back before court. We'd have a hearing, not whether or not you were, hearing wouldn't concern whether or not you were possessing controlled substance, or if you were driving while intoxicated. The hearing would be about your violations. And if the court finds that you violate, the court would revoke your community supervision and your sentence would be these sentences that you're entering into today.
Yes.
So you understand that and you want to go forward. Okay. Then to possession of a controlled substance in penalty group 1, less than 1 gram, and driving while intoxicated. How do you plead to those charges?
Guilty, sir.
And Mr. Haywood, are you pleading guilty to each one of those because you are guilty of committing those charges?
Yes, I am.
Mr. Haywood, has anyone threatened, forced, or pressured you to plead guilty to either charge?
No, sir.
Court accepts the defendant's plea of guilt then. Ms. Thompson, any objection to states 1 in each case?
No, objection.
All right, then states 1, the evidence and stipulation of evidence in each case is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would just note that Mr. Haywood was clearly in a better place today than he was.
Good. And from the defense, anything further? All right, so Mr. Haywood, I'm just going to take a second and read over the case. Mr. Ulrich, I'm trying to find a lab. Do you know if there's been a lab? I don't see a lab in the PCS case. Let me see if it's attached to the DWI case. Find me a lab. Mr. Abraham can get it if you'll tell us where you're printing it. Got concerns about the certificate of discovery here. It's blank. CR 21-122, it says there's nothing provided in discovery. Just the fields. Kind of blank. What's that? All right, so Ms. Thompson, is there any objection to what will be marked as State's Exhibit 2, the laboratory kit? You want to see that? Okay. All right, then the court will admit State's Exhibit 2 in CR 21-122. Yes. Oh. Mr. Woodrock, are you working on that certificate of discovery? Is that what you're working on?
Yes, Judge, for whatever reason, it's not wanting to pull everything.
If you want, if it doesn't work, then the certificate of discovery in the misdemeanor case, no, it's different, but I don't know if it arises out of the same transaction. This one looks correct. This one, I always allow you to make a copy of that. Just change the cause number. Yes, ma'am.
But you saw, you were looking for it, you can see it. So you saw it wasn't laying there, right? So I think it was paperclip.
All right, Mr. Haywood. Court has reviewed the evidence and in cause number CR 21-122, court will find that there's sufficient evidence to convict you of this offense. Court will follow the plea agreement in this case and also in CR 21-149. Court convicts you of the state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram. Assesses your punishment at 2 years confinement in the state jail division of TDC. Court will suspend that sentence today and place you on community supervision for 3 years. Order you to pay a $1,900 fine, $180 restitution, $290 court costs, and $935 reimbursement fee. Court orders this sentence to run concurrent with cause number CR 21-149. In that case, the court follows the plea agreement as well, convicts you of driving while intoxicated, Class B misdemeanor, assesses your punishment at 180 days confinement in the county jail. The court will suspend that sentence today, place you on community supervision for 2 years, order you to pay a $100 fine in that case, $15 reimbursements, set $270 court costs in that case. You're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted, the bailiff, and after that, step over here with these officers and they'll give you additional information. Yes, thank you, Ms. Thompson. Yes, sir. So I don't need this forced osmosis. That one's blank. That one? No, that was the copy you were for earlier.
The good one or the bad?
That's a good question. Oh, I've already given the good one, but she was fingerprinted. So this was what we were before. That was not signed. But that you said you attached my office. I think it got attached to Haywood's. And this was the blank copy.
Mr. Carroll, who you called previously, this is Mr. Ashmore, Mr. Ashmore's client. Judge, we set it for October 10th. That's a Sunday. It should be the 12th or the 14th of the day.
Did they just write it down wrong?
I believe you said October 10th because that's what I wrote down. That's what drew
It's October 10th.
my attention to it.
Okay.
So if we could have him set on a different day, give him notice, and then if we can notify. Mr.
No, we'll
Ashmore.
just come on Sunday. I'm just teasing.
You're
You
fine.
gonna
You're
come
fine.
on Sunday? Did you catch that mistake? Will you give me a new notice to say? Let me see that. I'm gonna fill out a new one. Well, I'm glad that you're still here. So you don't want to come on Sunday? You sure? Where else are you gonna be on Sunday? Church? Panel was looking for church, but I'll take home as well.
Home
I'll-
taking care of business, Judge.
Zoom church.
I'm getting ready for church.
If I said that, my apologies.
I didn't catch it until you told someone else that the dates that week were the 12th or the 14th, and I said, in my head, I just wrote down 10.
I was
That
probably thinking
clearly-
10-10.
Clearly, that cannot be correct. One of those is not right, so I looked it up.
And he's just set for pretrial, not jury trial, so.
Yes, Judge. He
Alright,
was
so
just
I'm-
arraigned today.
He just signed his papers.
Yeah. So I don't know why jury trial was checked. All right, so Ms. Carroll, I'm just gonna have you sign right here. We're gonna give you a new one, okay? What was it supposed to be? 10-12, right? It says 10-12 on there, right?
It says 10-12.
All right, so I'm just gonna get rid of this one here. Thanks, sir. Give you the back. I have one. Okay, I know we're in the lunch hour. Let's finish this up real quick. This is CR 21-219, State versus Christopher Bernard Hawkins. We have confirmed that he is in custody in Madison County, Mississippi. Is he federal charges? So the court is going to find Mr. Hawkins' bond to be insufficient at this time. Court will set new bail at $50,000. You know what, you're gonna give me a new one of these because I've messed that one all up. Give me a new one, give me a new one of those, 'cause that one, I have messed that one up.
We don't need a bail certificate.
No, not these two. CR 21-206, State versus Lemmy Jean Brandon Jr. or John. Court's gonna find that Mr. Moorhead is currently in custody in Moorhead Parish, Louisiana. Court's gonna find his bond of $50,000 to be insufficient. It's gonna set new bail at $100,000. I think I did the same thing. No, you won't. I'm just gonna already messed it up. I might as well just keep messing it up. I'm the only one that's gonna look at it anyway. Court of Appeals, maybe.
If you want me to, I can fix this.
So you don't have to. All right, the only nice size, if any. Keith Mays will be at 130. Dakota Dubose,
Yes, sir.
Chrissy Carlton.
All right, bailiff, was there, did you call Troy Burgess and Dakota Dubose' name loudly, distinctly 3 times in any response? All right, court having called CR 21-212 Dakota Lynn Dubose at 9 a.m. Dakota Dubose was not present. Name has been called loudly, distinctly 3 times in the courthouse. In addition, the court has also called the name Troy Burgess in the courtroom. Was not present at 9 a.m., not present at this time. Name's been called loudly, distinctly 3 times. No response. Court here hereby issue judgment nisi for Dakota Dubose and Troy Burgess.
Oh.